Morning, good afternoon, and good evening, wherever you are. Welcome to today's show, Face the Nation GH, trending issues and rebuilding Ghana. For one reason, let me apologize to everybody. And it ain't me for trending issues, but you can get a quick into the legal issue, as the topic of the day and rebuilding Ghana. We are still at Ghana Supreme Court. You see, a lot of issues, ACC or court, or once more, welcome you be. As I always say, program, like I said, divided into three: the introduction, the trending issues, and the rebuilding Ghana. Why? Yes, specify on a particular topic. But because of Ghana court issue, lately, I focus so much on that. In the past, we've been doing issues on economics, issues on security, but now, the court issue, as it stands right now, it's clearly that it's coming to an end. You focus some time on. This is what is happening. As at the last time court give you ruling on February 11th, I believe this will happen. But anyway, let's. All right, back to the issue. As at February 11th, this is what the Ghana Supreme Court said. That was prior to that, not Oma Babe 11th was on Thursday, but prior to that, now Oma Babe legal arguments. Whether say petitioners in which may compel the first respondent and a witness, which is Jane Mensah, into the docket box. Now call my cross-examination. That was the purpose of our hearing, but not to go back so much. And our court came out with rulings say a party cannot compel a party to give witness. Okay, you're making it so simple. That was the position, or that was the issue before the court. And the court didn't rule here. That issue, some of us said that court actually came out with a lot of case study, like case law, they arrive at the conclusion. In the movie breakdown, you believe he said where the court said, and they said, also in light of the evidence and the facts and the cases almost cited, almost consider, almost dismiss that objection NDC for a movie, with that motion is a MBP, lawyer, case first responder and lawyer and case all man testify, but they are done with their case, And that was what they were thinking said. Almost file that objection on the motion arguments, and according to ruling said almost compel a party, Emma party. So right there we saw what Acheampong did. Or standing on his feet, file or catch a court and say, obey movie motion, intend to file a motion to subpoena Jane Mensah to appear before the court. Which subpoena is different. Here the subpoena is not voluntarily. The last video, let me say you discuss about what subpoena is. We don't want to go so much into it. But just a recap now. Then court now, look at say it's a court of records. Since Oma Kasadia put it into application. Until you say and I also make it court in aware say ruling no deny some Jane Mensah and Mama testifying because a party now compels our party no. Chikatakas over appeal our decision. So at this point there are two issues. Either Chikata intended to appeal as at Thursday 11th of February 2021. So let's see what happened. So that issue I believe is a pending. Then Chikata as file a motion. That motion wasn't necessarily said they need the court to grant them or to compel the EC. Not EC, almost just subpoena. No, they don't need the court to do that. But what they need the court at this point in say, normal closely as at February 11th, normal closely almost substantive case, more arguments, Okay, so more approach court, so court no more leave so that they can reopen their case. Normal to me, I compel because they never thought or they didn't anticipate. Say, now after almost case, and Kasa no already know affidavit that court. So, Obek testified because of a court ruling on inspection of documents and request for interrogatories. This is what the court said. Court nigga says our questions ground up so say you see na mount you see witness which is James and mounted witness box now. They will have the opportunity to ask all these questions. And here is the case there. It drew so for to do that, why and the court has now educated us say or cited a lot of case laws. I know a lot of people may have opposing feelings to that ruling, but from me, my perspective, I think based on the cases I caught by any day, the court at this point is telling us petitioners are to me unconvincing because it was solely on case law. Now, the normal, check out a file motion to seek leave to reopen the case. Not court anymore. I would deem that as an emergency hearing, as at Monday. To almost call Monday, this will happen. The argument Chikata put forward and the opposing argument from the EC side was said. The burden is on the petitioner to prove why court on more grounds, no more reopen case. And this is what happened or transpired as at Monday, which was 15th of February 2021. I'm sorry. Omo movie argument and they say now omo anticipation and say can you see no Bible testify so that give them opportunity. Normal question on certain issues we are omo nyakwan and me have found back before the court. But here's the case you see no. Yes, and they also further establish another argument. Says here, the electoral commissioner, right, a body of cooperation, meaning as a body of cooperation, said next, so because we sue the Electoral Commission of Ghana, this is where the confusion is. But this is my understanding. I don't mean say I'm binding anyone. As a body of cooperation, it's entirely different from say, okay, for instance, there's a Ghana, there's the Electoral Commission of Ghana, a body, corporate, it's a corporate on its own. An employee may work there today, the employee may not work there tomorrow. For instance, Ubusa won't say, former EC boss on Charlotte Oweya, she has been fired. She doesn't work there anymore. This will be bring a lawsuit. Want to mean serious if I want to bring a lawsuit against the Electoral Commission of Ghana, maybe based on conduct B or polling station B and as elections be conducted, mean to me, because me could see chairperson. No, I'm bringing a suit against the Republic by citing the commission as a main party. So now, I'm going to argue to distinguish between, say, Yisimam and we're entirely different and is a distinct individual from the corporation. And if that is the case, I say to court to me allow no subpoena that particular individual because the chairperson and also the presiding officer where presidential elections are concerned. So that was a simple argument. If that is the case, like a court no more committing a subpoena, and a court also go here and says they couldn't prove case. That was Monday, and almost argument. And East side also coming out with a very cogent argument. But I think the petitioners did a very good argument here. The reason I'm focusing so much on them because the burden was on them. So, movie. Then the court gave them, which is February 16th. That was today, okay? So in the they were there for hearing of arguments number on Monday, And they were also there for Chikata motion now or appealing the review now or seeking for CNTR into me issue my men or testify mounted witness boss So I had two issues. And then they got a ruling. The court came out, even though the court cited a lot of issues, okay? Court and cited Nyoma be case laws and in Nyoma time we munya opportunity. But all in all, say the court and conclude, no say. Almost exercise what we call discretionary powers. They are court okay. Court and so almost use almost discretionary powers. And you know, almost granted NDC for motion. I know it didn't. I mean, it wasn't in good faith with the petitioners, but that is a position of the court, or that is a position of Supreme Court justices. No. So follow-up questions I be by in and I check out a reminder say while filing appeal our first hearing I see imaginements and mountain. But at this point, now Chikata is trying to tell the Supreme Court justices and say there's an error in their ruling on February 11th. Because the Supreme Court had narrow case and they say a party cannot compel a party, okay, to mount the witness box or to give testimony. It's like I'm forcing assuming I'm the plaintiff, I'm forcing the defendant or defendant witness to come and testify. And now, if that is the case, that's the Supreme Court to me admit to say, or NDC petition lawyers need to me come out with a very strong argument, extra court, and they say indeed, yes, on your party there. Therefore, the Supreme Court is self-faulted, and that is what Chikata and Co is trying to tell Supreme Court. And now, in the ruling, but you say Chikata yadi so we are sorry no catcher almost say, or by filing motion or filing motion. And when you was stepping, it say the date ben here the amano. Because at that point it's like or China journalists say what filing motion it means I think I assign you to a date. Because so reminder say the initial orders now court in issue here. Those orders are still in place. Meaning on the 17th and on the 18th, which is Thursday, on be me to a court with their closing arguments, Then afterwards, on a court now finding their mom, ruling. So it means it's like, look, when you start hearing this, it's clearly that the case is coming to an end. So Chikata is also, if I should say, because he couldn't indicate so I'll just say he intends to file a leave of filing stay of proceedings. And what that means is the stay of proceedings, the court granted the stay of proceedings now. It simply means, say, or compel the Supreme Court justices, the first respondent lawyer and the second respondent lawyer, to stay off any case precisely they are targeting the Supreme Court justices. Say, I'm moving forward. They shouldn't do anything. They should stay off everything until, say, Oma addressing the review, no, give you on 11th February, That is what it means for the stay of proceedings. And, I think the almost space in here very limited, looking at what is happening right now, Because today is on the 16th, you just have on the 17th. But I always say this, irrespective of how strict or how the court wants to comply with the CI 99, the court does have the power to extend the dates. Say CD 45 days in the Quran, they can still extend it. Almost our power need to do that. I wouldn't cause anything. But where I'm seeing it is, I'm saying court in the hands, petitioners in the hands are very limited because they have to come out with a legal briefing arguments, which is they only have Wednesday, which is December 17th. So is it a court number calling for emergency here and as a court number extending a old order on Thursday, February 18th. Now we're more room to come and litigate. So let's see how they be communicated to them. So let's see if the court is likely to meet them tomorrow. So it's like there's so much uncertainty. But you see, some of the questions I'll be posing, and the Supreme Court Justice can say, I'll say, amongst the 5 issues, court Nankasa narrow almost cases in 5 issues before the court. That's what they were going to use to determine. But amongst all the 5, the major one or the most important one, I think that there was a misconception there. It would be more court and see the 5 in one, but that's the emphasis. Almost amongst 5 but quite important to the invocation of Article 63, meaning that the petitioners have to show, say, one party precisely, the respondents, which is the first respondent, and to me, the second respondent and meet the constitutional requirements or the mandate, which is 50+1, and now the first respondent are confirming. So at the end of the day, that's what the court is likely to base the final verdict on. So NDC4 were they able to prove to us, and what they get it in with that issue, and say any 4-year independent verification of the pink sheet and almost disprove the way. But you see, I think you also have a lot to give us because as it stands right now, there's a conflicting resource that is in the Aba. So court now coming to an end and answer a closure now. We share much information from the defendant's side now or the basis on now. So it means no more limited all the evidence and the facts solely on the petitioners to do this. And here's the case: the petitioners also believe saying the tools of discovery, which is the interrogatories in about 25 questions. They were even asking just 12 questions. Even in small claims here, some people can even ask 25 questions, where people contend or contest on amount of $50 or $20 or $200. A hokra and be most 7 interrogatories. So it have that tendency to affect the outcome of the ruling, and it is no doubt. And I say there was another issue. Court and also a pass comment. Be say, what does the chairperson needs to account to the party if she Jane Adukoye Mensah is not a party? Now, or getting back to petitioners, an argument not making sense. I must say, Nipa no on your party to this issue, dear, and at the end of what to account to the people. That's what the Supreme Court justices is supposed to petitioners. And now I believe the petitioners, it's likely to almost appeal. They are likely to make it clear to the court, say, or a public servant, no doubt. Therefore, the services are rendered to the people of Ghana. You bet me a subpoena. Because it helps in any civil proceedings. Be a litigate here, ultimate subpoena, or be a grandpa or interested party to the case. But the testimony be an answer and account of you be given a bit me a boano. Bet me bring it that person before the court. Look, all in all, so we shall court an exercise of discretionary powers. I hear so much until now. Ama and Kofu be I started no problem. Because you see, let me conclude on this. When you say discretionary powers are okay, it means it's more subjective or it's more the spirit of the law, not the letter of the law. What do I mean by that? What I'm trying to imply here is that when the court or the justices tells you that we are using subjective or our judicial discretionary powers meaning in light of the facts and in light of the evidence that has been presented, yes, still, I can say the yepe. I consider so anyone by the yepe any give it this ruling. I'm say, and you say happen, and also names a lot of issues but all the same, I will just say a very good evening to everyone and thanks for your time.